I'd like to welcome you. Thank you for coming. And Mr. Pemberton is going to conduct this meeting. So that's that.
Okay. Thank you all for being here. The purpose of this hearing is, there's only one purpose of this hearing. The school system has given notice to the elections board that they question whether or not Mr. Kendall satisfied the educational requirements necessary to run for the election. As such, the
She needs to go to the other door.
As such, the issue for the board this morning is going to be to listen to both sides of this dispute, to hear their testimony, to review documents that they may place into evidence, and to then the ultimate decision is whether or not Mr. Kendall is eligible for to be on the ballot, would be the correct way to say that, whether or not he meets the qualification requirement. And that's the only issue. So we're going to get going first, and what we're going to do is we're going to ask Mr. Shepard as the school board attorney to present whatever evidence they have available, any testimony that they would like to offer on the issue of whether or not Mr. Kendall is eligible for re-election. Witnesses will be sworn. They will be subject to cross-examination by the opposite parties as well as by the board. And as I say, we have a court reporter here who will take this down verbatim. Now, before we get going, does the board have any questions? Okay, Mr. Kendall, Mr. Shepard, any questions about the procedure?
Well, I just got one thing I'd like to raise before we get started, Mr. Fortune.
Okay.
You know, Ms. Grayson, I take it that you saw my letter yesterday requesting that this hearing be postponed because I haven't, in my opinion, been properly notified of exactly what the specifics of the challenge and the specifics of what year is the board challenging my qualification concerning this training, because it did not state in the letter. So I haven't had an opportunity to try to ascertain all of these records. Some of this stuff is at the School Board Association in Atlanta, some of the Department of Education. People at the Department of Education, they only take phone calls on Tuesdays. And so if we are going to hear any testimony, this is going to be an inquiry about whether or not I went to this training, then I think this hearing needs to be continued. If it's going to be an inquiry about the law as to whether or not this statute applies to me, then I'm prepared to go forward this morning. But if it's going to be an inquiry about whether or not I went to some training in a particular given year, I'm not prepared to answer those questions and provide any evidence to the board this morning because I haven't had an opportunity to figure it out.
Well,
Okay, I understand.
right. So, and Mr. Kendall did request the continuance yesterday, and we decided the way we would handle this, and I told Mr. Kendall this a few minutes ago, we get into this hearing. If he believes that he needs to request a recess to allow him to get additional records, and if the board believes that those records would be material to their ultimate decision, then we can, of course, recess if we see fit for a certain period of time and give him that opportunity. On the other hand, if the board thinks that these additional records would not be of any assistance to them in reaching the ultimate decision, then they could deny his request and say, no, we're going to continue on with this and reach a decision. So I think we understand your position completely.
Well, can I make this suggestion in the interest of everybody's time? I think there obviously is a threshold question as to whether or not this statute even applies to me. I think you have that letter from the Legislative Council, and a second memo, I guess, from Mr. Lanier, who is the Deputy Legislative Counsel, agreeing that the statute doesn't even apply to me. So to me, it would really be a waste of everybody's time to be going through all this training stuff if the statute doesn't even apply. I think this board ought to make an initial determination, and let's argue this point of whether or not the law applies. And at that point, you decide that the law does apply and that I needed to have taken this training, and then we can get into whether or not I took the training. But it really doesn't make a whole lot of sense to me to go spend all this time talking about whether or not I went to training if the law doesn't even apply. Wouldn't that make logical sense?
Hang on a second.
You're fine.
Mr. Shepherd, what are your thoughts on that?
Well, first off, I want to clarify now, the school board is not here as a party, and I'm here as a witness, not as an attorney.
Right,
But you've asked me my thoughts.
Yeah.
This board, when it met Friday, was a week ago, I don't remember the date now, and asked for communication from the school board with regard to this. And the board met yesterday and adopted a resolution which we would like to present to the Board of Elections. And in that resolution, the school board found Mr. Kendall had not met his training requirements for fiscal year 12. I also have a packet of documents that we put together. I think Ms. Grayson, you already have a copy of them because you had delivered them to Ms. Collins some time ago, which shows how the superintendent came to write the letter dated February 25th to Ms. Collins, putting the Board of Elections on notice that there was an issue. So if you're going to have a hearing from the school board, we at least want to have that in the record. We want to have the factual and the legal basis for Dr. Jones writing the letter, putting the Board of Elections on notice. Otherwise, I don't know that the board has a complete understanding of what the issue is. You need to have the factual basis for the challenge to start with, which is the fact that Mr. Kendall did not get his training requirements. And I will tell you, there is no factual issue with regard to that. The document that Mr. Kendall is talking about is a legal document that the superintendent is required, let me finish, is required to file with the State Department of Education annually, and it's signed by Mr. Kendall. So, I mean, there's no question as far as the legitimacy of that document.
Okay, wait, just a second. However, if the board were to determine early on that this statute did not apply to Mr. Kendall for whatever reason, then the rest of this evidence would really be moot, wouldn't it?
If the Board of Elections were to find that the statute did not apply to Mr. Kendall for whatever reason, then they apparently would not be considering the evidence. But I, on behalf of the superintendent, want this evidence in the record to show why Colonel Jones wrote the letter to the superintendent of elections or the board of elections.
Okay, as I understand it, an appeal from this is not a de novo proceeding. It would be simply a review of the record.
That's my understanding.
That's your tip. Again, my point is that if anybody wishes to appeal the decision of this board, the appeal would be confined to whatever record, whatever documents and evidence were quoted in the record. And if they're not in the record, they would not be considered. So for that reason, although what Mr. Kendall suggests would certainly be a more expeditious way to proceed, I would suggest that we stick with our plan to receive the evidence and hear argument, and then at that point in time decide whether or not, or a question of whether or not Mr. Kendall is eligible for re-election. So I would recommend that you proceed that way.
Well, may I make this point, Madam Chairman, Mr. Fortune? Number one, the school board doesn't have any standing to complain about anything.
I'm not answering.
So, but my point is, they're demanding what they want in the record. They don't have any standing to demand anything about what they want in the record, because they don't have any standing to challenge my qualifications. So what the school board and Mr. Shepherd may want in the record, as far as I'm concerned, is completely irrelevant, because they don't have any stand. They're just a witness.
I understand.
And if the board wants their testimony, then you can ask for it. But he doesn't have any standing to demand or anything to be in the record. And number two, I think all of us can clearly understand, irrespective of what Mr. Shepherd is saying, that if the statute doesn't apply to me and I didn't have to do any training, then all this stuff, all these records is irrelevant. So I'm going to be objecting to anything until this board decides, number one, that this statute applies to me and I had to train, period. Until you make that threshold determination, all this other stuff that he's talking about, all these training records, is irrelevant. And I'm going to be objecting to any admission of that stuff.
Okay.
Part of that was that they were trying to show that you did indeed know that those were the rules. We need to some kind of understand, because we had no clue that this was part of how you had to, what you had to do in order to qualify. So I believe we do need to hear an abbreviated version.
Well, but first of all, you got to determine
this is
whether or
our
not.
hearing.
Well, Mike, excuse me, Mr. Kennedy, I think they've determined they want to hear, they want to have a complete record. So if this matter is appealed either by you or maybe somebody else out there that would have, unless, I don't know, we're going to have a complete record, okay?
Well, I'm going to state my objection for the record.
Go ahead.
That any of this documentation concerning any training is irrelevant unless and until you determine that I had to train in the first place. Because if I didn't, it doesn't matter whether or not I had what their record showed.
We'll let you have a standing objection to any document they put in. You're not going to have to restate it on the record every time. So if the documents have anything to do with whether or not you met the educational requirements, your objection is it's irrelevant to a hearing today and should not be admitted. Is that a fair statement?
Yes, that's a fair statement. And I'm also asking for a continuance so I can refute their records, which I haven't had opportunity to ascertain the records.
That will be a matter that the board can consider as we proceed to see whether or not they want to see additional documents. How about that?
Yes, sir.
All right. All right. Any other questions? Mr. Shepherd. Yes. Okay, let's see. Who's going to testify? Mike, you going to testify?
If I need to.
Can I swear you? Do each of you so swear the testimony you're about to give in this matter pending before this board will be the truth, the whole truth, nothing but the truth, so help you God?
I did. Yes, sir, I do so affirm.
All right, good farm. Close enough. Mr. Shepherd, do you have any evidence or any testimony the board would like to offer on the question of Mr. Kendall's eligibility for re-election? Please do so at this time.
I guess first off, I need to state my name and who I am for the
Good
record.
idea.
My name's Tim Shepherd. I'm a member of the bar. I have a local practice here in Griffin. I've been practicing law. June will be 33 years. I am general counsel for the school board, the school system at Griffin Spalding. Been representing them for about 17 and a half years. I'm a member of the Council of School Attorneys in Georgia. Mr. Fortune, this issue came up when qualifying for seats 1, 3, and 5 on the school board was coming around. And it was known by the superintendent, based on records that were sent into the state, that Mr. Kendall had not gotten the required training hours in for fiscal year 12. Based upon a statute that was went into effect on July the 1st of 10, we believed, and we being myself, the superintendent, and the board chair, Mr. James Westbury, when we talked, that created an issue about Mr. Kendall's eligibility to qualify for re-election. That belief was based upon the universally held belief among the representatives or employees of the State Department of Education, Georgia School Board Association, consistent with all the board training that board attorneys, school board members had received with regard to the effect of this statute, which was that it mandated board training, and if you did not get the board training, it could affect your eligibility to run for re-election.
Tim, can I interrupt you 1 second? Just a point of clarification. Do I need to be objecting to stuff just for the record? I mean, if he's making hearsay statements and all that kind of stuff, do I need to object so I can, and you gonna rule on this kind of stuff?
I think the best thing to do, since this is not exactly a trial, I think we'll just accept the fact that you're probably going to object to everything Mr. Shepherd says, and that you're not under any obligation to object. He can state their position.
No, I mean, these statements like it's universally believed by everybody at the State Department of Education. I mean, statements like that are just clearly.
Well, it's clearly argumentative, I understand that, and we can let you gentlemen argue later. Right now, we kind of make this more of a, we expect to show X, Y, and Z, kind of like a standard opening statement. That might be the better thing to do. You can argue these points as far as what other people's opinions may be, if that's all right.
Mr. Fortune, I said that in leading up to giving you a couple of documents, so that the board would understand the context of it. And I was asked to bring some documents, and so I've done so. One, and I don't have, I'm sorry, I didn't bring any evidence stickers. One is a copy of the resolution which the school board adopted yesterday.
I'm going to put a bunch of stickers on these so we can identify them.
Yeah, you want to mark each one? I've got one original, and then I've got a copy for each of the board members.
That's fine. Why don't we just do the originals?
Okay?
Is this 2 documents?
No, that's one document. That's the resolution. The copy to the board members.
Okay.
And this is a collection of documents.
Why don't we let your resolution of the Griffin Spalding County Board of Elections be exhibit number 1. The school board.
For the record, I got, Mr. Kendall already has a copy of the resolution. He had that last night. There's the compilation of documents there.
Here are your resolutions, which we pass out. Yeah, this is an original right here.
Well, it's,
I mean, this is the one for the record.
right, and then,
This is going to be exhibit number 2, which is a, looks like to me to be number of pages, OCGA section 20-2-51, and other various documents, school board governance requirements, school regulations, etc. Those will be collectively marked as exhibit number 2.
Ms. Fortune, you ready?
Sure.
Oh, okay, I'm sorry, I was waiting on you. This board requested the last time it met that I prepare an opinion letter for the Board of Elections. I didn't feel that it was appropriate for me to do that because I'm not the attorney for this board. I was requested to prepare an opinion letter for the school board, and I did so. And presented that to the board yesterday, and I provided Mr. Fortune with a copy of the opinion letter. I don't know if he's made copies for y'all or not.
No, I gave a copy of that to Ms. Grayson and went to Ms. Colling and asked them not to dispense that to board members, since I wanted that to be presented by you.
I didn't make copies, but and I'm gonna try to. I'll warn y'all, like I do other folks. My wife tells me that I'm the only person she knows that if you ask me what time it is, I try to tell you how to make a watch. So I'm going to try to keep that in mind and be a little brief, but I do want to run through this, and it will end up explaining the context for my opinion.
Would you like copies to be made to give to them, or would you
I
rather just?
don't mind that bit. That'd be fine.
Would you rather just summarize it for them? Oh, they got it? Oh, okay. That was the. Okay, they have it.
Okay. All right. In looking at the documents that are on exhibit number 2, there's 2 things that you're going to see. Two issues that really are not in question. The first is whether or not there is the obligation of school board members to get the mandated training. There is no question of that. If you look at the statute 2251, it refers to the training requirement. If you look at the state board rule, which is 160-5-1-.36, it references the mandated training requirement. If you look at the third set of documents, which is from the Georgia State Board of Education website, training program provisions, training requirements, newly elected members of boards shall participate 15 hours. B, board members with 1 or more years of board service shall participate as a minimum in 9 hours of training annually. If you look at the fourth set of documents in Exhibit 2, Descriptor Code BH, the local board code of ethics, if you flip back to the flagged portion, conduct as a board member, board members shall participate in all required training programs developed for board members by the board or the State Board of Education. A part of Senate Bill 84, and I'll get into the background on that in a second, was another statute. It's 20-2-230. That is referenced in my opinion letter. 22-230, in 22-230, the legislature mandated that the State Board of Education develop mandatory training programs for existing board members. The second subsection of 22-230 mandated that the State Board of Education pass on to local boards of education the requirement that each board adopt a training program for its members on an annual basis. You have to develop a training program. If you look at the minutes, you've got a copy of that in Exhibit 2 from the school board meeting from September 27th of 2011. First off, you'll see that all 5 board members, including Mr. Kendall, were present. If you flip over to the tab portion of that, you see where the board unanimously adopted the training program. If you look at the And this is for the year in question, which is fiscal year 12. When the State Board of Education adopted their annual reporting period for the board member training, they adopted it on a fiscal year basis. So the fiscal year that's in question here goes from July 1 of 2011 to June 30th of 2012. The next document in the packet of documents you have is the actual board member training plan itself. It's a one-sheet document. It's highlighted, and in that you will see that the Griffin-Spalding County Board of Education adopted a training program providing for 9 hours, 6 of which would be taken at the GSBA Student Achievement Workshop to be provided on December 1st of 11. The other 3 hours was required whole board member training, where the entire board has to get the training together with the superintendent, and that was provided at Griffin Resa on October the 25th of 11. Okay. If you look at the next document, it's the last document in that packet, it is the reporting report, or the Local School Board Governance Annual Training Report, which Colonel Jones, just like every other superintendent in the state of Georgia, is required to send in to the state on an annual basis. In that report, all the school board members had to certify by their signature how many training hours they received. That report covers fiscal year 12, which is July 1 of 11 through June 30 of 12. And you see Mr. Kendall signed off on his report certifying that he'd only received 3 hours. So I told you when I started this that there are 2 things that really are not in question. One is the requirement, the legal requirement by statute, by state board rule, and by local board rule to get the mandated training, which is 9 hours. The second thing that's not in question is that Mr. Kendall failed to get his 9 hours for that period. Colonel Jones has brought something on his laptop, which is basically the video of the June 26, 2012 school board meeting, where this document that I just referred to was passed among the board members, discussed, and signed, where Mr. Kendall acknowledged in that meeting that he had not gotten his training out. In fact, Colonel Jones will tell you that he didn't have to do the reporting until sometime after July 1st. But he did it at the June board meeting, so Mr. Kendall still had a few days to where he could have made up those 6 hours going online to get them. Colonel Jones will tell you that gives you the background on the opinion letter that I provided to the school board. And I'm going to try to be brief on this, but I do want to give you the background as to why I respectfully disagree with the opinion letter from legislative counsel and apparently Mr. Lanier's opinion on it. You got to go back to 2008. In 2008, the Clayton County school system lost its accreditation. All public school systems in the state of Georgia have to be accredited by one of 2 different accrediting agencies. SACS is the one that it accredits us, it accredited Clayton, I think it probably accredits 95% of the school systems in the state. But SACS is who we have to keep having. When Clayton County lost their accreditation, it created a furor. If you remember 2008, those of you who may be associated with any real estate, real estate was tanking, and it doubly accelerated the rate that the real estate up in Clayton County was tanking. Business owners were in a furor. I mean, losing accreditation of the local public school system is devastating to a community. Elected officials, especially in the governor's office on a statewide basis, found in 2008 they were powerless to do anything about problems with the local school system. So the governor created and appointed the School Board Standards Task Force in January of 2009. Excuse me. That task force was made up of statewide leaders, business leaders, people involved in education, people from the business community, you name it. And they came up with a very comprehensive report. That report addressed the issues that task force perceived to be as problems with the local public school system statewide. The main problem they saw were what they referred to as governance issues, which is basically the local school board statewide. Their report made comprehensive recommendations as to how to address those issues. Part of their report was a massive overhaul of ethics requirements for local board members, conflict of interest requirements for local board members, nepotism issues with regard to superintendent versus local board members versus high-level administrators in school systems. One of the other things that they addressed, and that's the issue that we're here on, is board member training. The theory was that if board members are better educated or trained on what their legitimate role is and their requirements are in their role in local public education, that you'll have better board members. From that governor's task report, we got Senate Bill 84. Senate Bill 84 was a comprehensive bill that added new provisions to Title 20 to the code, which is the education code. And I'll just tell you, my opinion is, and I'll tell you how I got to it, is that the legislature intended to make the failure to obtain the required board training as a disqualifying factor for eligibility for re-election to the board. Had a couple of highlights as to how I got there, because you've got to look at it in context. First off, if you've got the opinion letter in front of you, as a preamble to Senate Bill 84, which is 20-2-49, the legislature made these findings. And I'm going to get down toward the bottom of it. Given the specialized nature and unique role of membership on a local board of education, this elected office should be characterized and treated differently from other elected offices where the primary duty is independently to represent constituent views. Local board of education members should abide by a code of conduct and conflict of interest policy model for their unique roles and responsibilities. And although there are many measures of the success of a local board of education, one is clearly essential. Excuse me, maintaining accreditation. In Senate Bill 84, as I've stated a little earlier, the legislature included a statute 20-2-30, subsection B1. The State Board of Education shall adopt a training program for members of local boards of education by July 1st of 11. Subsection B2. Within 3 months of adoption by the State Board of Education for training program pursuant to paragraph 1 of this subsection, each local board of education shall adopt a training program for members of such boards that includes at a minimum, and it goes on to describe the minimum. The second statute, excuse me, that was part of Senate Bill 84 that dealt with board member training was 20-2-51E. Now, it's significant that the legislature chose to add subsection E to 20-2-51. 20-2-51 was the existing statute that provided for qualifications for members of local boards of education to be eligible for election and disqualifying factors to make citizens ineligible for service or election to a local board of education. So it's significant to me in determining the legislative intent that they chose to, as a part of the board member training requirement that they've already enacted on 22-230, to add this subsection to 20-2-51. I will tell you, as Mr. Fortune has already said, it is a very poorly drafted statute. And in my effort to obtain documents to go into an opinion letter, I've talked to a member of our legislative delegation as well as the legal counsel to the State Department of Education in Atlanta. And I think everybody agrees that this statute is going to take a looking at once the legislature wraps up their session and taking a look at it and seeing if we can't do a better, or they can't do a better job of drafting it. But when you look at trying to make sense or interpret the legislative intent in passing a statute, there are accepted, excuse me, there are accepted procedures that you go through. And I tried to go through that in drafting my opinion letter. The cardinal rule of construction, and you find case after case after case that will say this, is that the courts, because it's usually the courts that are trying to interpret this, shall look diligently for the intention of the General Assembly, keeping in view at all times the old law, the evil, and the remedy. Okay? Apply that to this case. What was the old state of the law? The old state of the law was you didn't have the mandated training requirement. The elected officials were unable to do anything when a local board screwed things up so bad that their school system lost accreditation. And what was the remedy? Well, one of the remedies, besides the comprehensive revision of the Code of Ethics, was mandated board training. What did the legislature do? Adopted one statute that mandated the board training, and two, added on to a statute that tied getting the board training to your eligibility to run for office. That's 20-2-51E. Excuse me. I'm sorry. I was researching actually another case yesterday, and I ran across this passage in another case. It's a Court of Appeals case from 2010. The language says, in construing statutes, courts shall look diligently for the intention of the General Assembly. The words of a statute should be given a reasonable and sensible interpretation to carry out the legislative intent and render the statute valid. Again, that's what I've tried to do. Now, I was asked to do the opinion letter because when Mr. Kendall appeared before this board, when y'all had the last meeting, his position was that the language of 22-51E, which said, in addition to any other requirements provided by law, no person shall be eligible for election as a member of a local board of education unless he or she has agreed to annually disclose compliance with the State Board of Education's policy on training for members of local boards of education. His take on that was that it only required him to do one or two things. It either required him to promise to disclose compliance, and whether he actually followed through with his promise or not, it didn't have any effect on his eligibility for election. Or it required him to promise to disclose whether or not he had complied. That was his position, as I understand it. I don't believe if you apply the terms of statutory construction, which says words of a statute should be given a reasonable and sensible interpretation, that is what the legislature intended in adding subsection E to 2251E. Because if all you're doing is telling a board member, well, you just have to promise whether you do it or not, or you just have to tell us whether or not you've complied with what we've already mandated as a training requirement, that really doesn't make any sense in addressing the evil that the legislature saw existing when they chose to adopt Senate Bill 84. In looking at that, I think that you've got to focus more on the word compliance. And I gave you the dictionary of compliance in the opinion letter. If you look at the Cambridge Dictionary, comply is to obey an order, rule, or request. Compliance is the act of complying. Merriam-Webster, compliance, the act for doing what you've been asked or ordered to do, the act or process of complying. Conformity in fulfilling official requirements. The reason that I disagree respectfully with legislative counsel's opinion is that he is focusing on the last unnumbered paragraph of that statute, which deals with the requirement to sign an affidavit certifying that you've complied. And as I understand legislative counsel's opinion is, he's saying that that affidavit, which Mr. Kendall didn't sign when he qualified to run in the November 2010 election, he wasn't required to sign that affidavit because the statute went into effect July 1st of 2010. I don't really believe the statute focuses on the signing of the affidavit as much as you've got to look at the requirement to comply with the training requirements. And if you look at the last line of that paragraph that Mr. I can't remember the guy's name, legislative counsel, but
Wayne Allen.
Thank you. Mr. Allen focused on, it says that the statute applies to members of local boards of education appointed or elected after July 1st of 2010. Mr. Kendall was elected in November of 2010, took office in January of 2011. So I have tried to be as brief as I could to run through why I think that 2251E mandates or ties compliance with training requirements with eligibility for election based upon what I determine to be the legislative intent. I will tell you, because this is a fairly new statute, there are no appellate cases. I contacted Georgia School Board Association, talked to their general counsel to see if there were even any superior court cases around the state that hadn't made its way to the appellate level. No, he kind of laughed and said that we're the guinea pigs. So we, I guess, we're all the collective, the Board of Education, the Board of Elections, we're the guinea pigs with regard to what this statute means and how it should be applied. And at the risk of repeating what I said a little bit earlier, the reason that Colonel Jones wrote the letter was that we realized it was an issue and that it would have been highly irresponsible on his part to have the requirement to report the training requirements to the Department of Ed, recognize that there's an issue and not raise it for somebody. And based on my advice, he wrote the letter that was delivered to Ms. Collins, apprising y'all of the issue and letting you do what the five of you collectively think is the appropriate thing with it. And that's the school board's position. Now, Colonel Jones has brought a couple of video clips with him that I think the board, y'all need to look at. But other than that, I'll be glad to answer any questions anybody's got.
Anybody here have any questions? All right. Go ahead.
Go right ahead.
Okay. So some of the questions that the board discussed in regards to the school board, you know, obviously within the school board's code of ethics and all of this, that this was within the 2012 year, you know, beyond the stuff in the Board of Elections code, what mechanisms for enforcing this training are within the purvey and the responsibility of the school board, so we don't get to this point where the Board of Elections is having to make calls within a realm that we really, you know, we exist to determine qualification or not. And based on this, in my understanding is this is a clear case where we should, but what should the school board have done anything in 2013, or what are the rules and procedures if a school board member does not meet training requirements?
Mr. Johnson, the school board has very few options. When a school board member is violating the code of ethics, the school board can convene an ethics hearing and essentially put that school board member on trial. A decision to sanction that board member requires a 2/3 vote. Our school board has 5 members, so a 2/3 vote is 4 votes. The remedies basically are very few. I mean, the board can't remove a board member. The board can't compel a board member to do something. They can chastise the board member, basically. So as a practical matter, there's not a heck of a lot they can do. Now, in this case, Mr. Kendall received communications from both the superintendent and a fellow board member. When he missed the board training, the scheduled board training at December of 11, where the other 4 board members got their 6 hours and Mr. Kendall didn't, Mr. Kendall had communications on a number of occasions that he needed to get his training hours in. The last, you'll see on the video that Colonel Jones has brought, where he's presented with the report form. He asked, I think Colonel Jones asked him, Mr. Kendall, is this correct? And he says, I guess it is. Mr. Holmes looks at him and says, Mike, you need to go get you some training. So other than just reminding him, asking him to do it, the board really didn't have a lot of other options.
Can I respond to the question?
Okay, you can respond to it during your section, okay? I mean, if you want to address that question to Mr. Kendall, you could, if you wanted to, or you can wait till his presentation and at that point ask him this question. Okay. Okay.
I have a question. You were mentioning the statutes, and you told us what your opinion is, what the state school board opinion is, then the legislative council's opinion is. Whose opinion overrules whose opinion?
Let me answer that. Nobody's opinion overrules anybody. None of these opinions carry the force of law like an opinion issued by a judge. It's their opinion. And that's all it is. It does not carry the force of law at all. That's what makes this really a difficult situation. There's no clear path here. It would be wonderful if we had an opinion issued by an appellate court or a superior court judge who gave some enlightenment on this issue. As Mr. Shepard and I'm sure Mr. Kendall will agree, there is just nothing out there. There are no cases reported. So nobody's opinion outweighs anybody else's.
And Mr. Hood, if I could, the way that the legislative opinion letter came about, I contacted Mr. Knott in an attempt to obtain minutes from the committee meetings, the legislative committee meetings, when they were debating Senate Bill 84. Was hoping there would be something in the transcripts of those meetings where the legislators discussed 20-2-51E. I mean, if you're looking at a federal statute, you can get that from Congress, and that's actually considered persuasive by a court. I found out that we don't have those at the state level. And as a result, David went further and contacted legislative counsel, and that's how we got that opinion letter. So we tried. We tried, it's just not anything out there.
Okay, any other questions?
Okay.
Good morning. I'm Curtis Jones. I'm the superintendent of the Brooklyn Spalding County School System. I've been superintendent since June of 2009. Is that enough identification of who I am?
Absolutely.
Okay.
I think everybody knows who you were.
Part of the reasoning that I believe it's important to move forward with this and notify you of this issue is because of the SACS requirement. I do believe that SACS is important, and they will be back to our school system in a year and a half. We just received a mid-year report talking about it. One of the standards that SACS is responsible for overseeing is governance. Our school board has been going to training with Georgia School Board Association every year since I've been on as superintendent. And Phil Hartley, who is the general counsel for the Georgia School Board Association, has conducted that 6-hour training. The training that's on the form that our board agreed to, those 6 hours were going to be given by Mr. Phil Hartley. And you can ask, I'll just tell you, there's no doubt that Mr. Kendall was absent of that training because I was there. Mr. Shepard was there. Every one of our board members was there. So there should be no question about did he or did he not do the training. He was absent, and we had conversations with him. What I want to share with you is a video clip of Phil Hartley talking about school board training requirements. Now I have it on my laptop. I think the best thing for me to do is just play it and turn it around and let you look, or
Let's go around. Yeah.
You want to take it over there?
Yeah, you could set it up right here, Colonel, and maybe they could then come behind you or.
however you want me to do it. Be a subject that came up, and I believe it would have been irresponsible for me to know that we thought it was an issue and not have it addressed. One question that Mr. Johnson asked, which is, what else could the board have done? Mr. Shepard has outlined those, but the other one they say is that if it is an issue that may concern eligibility, you bring it to the election board superintendent, which is what we've done. I think we have taken an appropriate response to what we thought was a valid issue. The second videotape I'd like to share with you is from our board meeting that Mr. Shepard alluded to, talked about, which is from June 2012. It shows when I actually took that document to show that Mr. Kendall had 3 hours, there was a conversation about it. because Mr. Kendall has said that he didn't know what we're talking about. Well, this video is his statements about what happened and what training he had received, and I want to share that with you as well. Training he completed, and I believe that it needs to be reported, and it would have been irresponsible for me not to share that information with you. I don't have anything else for you. What questions do you have for me?
Any questions for, Colonel?
Thank you.
Thank you very much. So to speak, you rest.
Well,
I realize you're not a part of it.
We're not a part of
I
it.
understand.
I don't
I
have.
understand. All right. Madam Chairperson, do you wish to take a break, or you want to go?
I assume let's go ahead with this.
Okay, Mr. Kendall, you have the floor, sir.
Okay, thank you, Mr. Fortune. First of all, Madam Chairwoman, I take it that if not, I'd like to submit this letter from Legislative Council, and it's, I guess, an email that Mr. Fortune gave to me this morning when I got here from Mr. Jeff Lanier, who is the Deputy Legislative Counsel. I take it that you already have copies of these two documents. This March the 12th, 2014 letter from Mr. David Knight from Mr. Wayne R. Allen, Legislative Counsel.
They have that one. They do not have Jeff Lanier's.
You haven't seen the,
We'll get it. I think you have his name.
Hang on, just a second. Are you talking about the one we got from Jeff Lanier this morning?
the one you just handed me
We
this
have
morning.
this here, and we can mark that. Hang on. I got 1, 2, 3 that are available. Terry, can we get 2 more, please? Make it 3 more, please. Mr. Kendall, you want to put those 2 in as exhibits?
Yes,
Okay.
I need to make a copy of those. I think
Sure. She'll bring me enough copies. Okay. We'll call that one 1 and this one 2. Okay. So the letter dated 12 March is going to be defendant's number 1, and the email dated 17 March will be exhibit number 2. We'll get those out over there.
They've got, Terry, just Betty. Oh, okay.
Give Mike 1 extra because he's got the originals.
Yes.
Yeah,
Lanier's name.
I guess you need to make a copy of that one too.
Yes.
Okay.
Thank
Those
you.
in chronological.
So just to clarify, that this from Jeff Lanier was to,
Okay, you should have 2 letters. The first one is dated March 12, which you don't seem to have.
You should have that.
we got that, I've got that. I guess I'm confused about,
Okay, let me tell you who everybody is. The first one, and I don't have a copy any longer, but the gentleman that issued the report dated, or the opinion dated March 12 is a member of Legislative Council. That is a group of lawyers who are employed by the General Assembly to assist them in drafting bills and doing legal research concerning bills. That's the longer opinion you see. Last Friday, I contacted Mr. Jeff Lanier, who's also Legislative Counsel, been there many years, because he, I mean, for a long time has been the kind of go-to guy on election law at Legislative Council. I knew him a long time ago when I was there. I told him about this opinion. He knew nothing about this case at all. And I asked him if he had time, I knew it was the end of the session, but if he had time to look at that opinion letter and tell me if there was anything in there he disagreed with or not. Either way, I would really appreciate a second pair of eyes looking at it. He apparently sent this last night about 7 p.m. I pulled it off my computer this morning about 8:15 or so, I guess. It's the first I've seen of it. I have given a copy to Mr. Shepherd and to Mr. Kendall prior to this hearing. So that's who those two people
Okay,
are.
and just to be clear, the opinion that Jeff Lanier is referencing is the opinion of Wayne Allen.
Correct.
Okay, that was,
Yes,
okay.
that's it.
Okay, so Mr. Porter, am I correct? I guess Mr. Lanier is, I know Mr. Lanier, what he used to do with the Secretary of State's office and Elections Office.
I think he did. Yes, he did. Yes, he had.
Dealt with him a lot of times in the voting rights cases now. I take it he is the #2 person, Deputy Legislative Counsel. Is that a little bit higher than just Legislative Counsel?
I can't answer that, but the other guy's just legislative counsel, and he's the deputy, so kind of
Okay.
sounds like it to me, but I don't know that.
And if I'm clear for the board and for purposes of the record, I guess, ladies and gentlemen, you have read Mr. Allen's letter. And as you can see, Mr. Allen's opinion is that in this particular case, with the set of facts that we have here, that this statute that we have in question does not apply to me, because that's what the letter says. Ms. Bryant, you're looking somewhat
Well, I was
confused.
looking at, why you think it does not apply to you?
Yeah,
Now, are you on the school board or not?
Have you read the letter?
I have read them, yes.
Okay,
But
well,
let's not get argumentative here. And let me give you some dates that, that might be of some assistance to the board. Mr. Kendall qualified on June the 28th of 2010. This, the effective date of the statute in question was about 2 days later on July the 1st of 2010. The election, when Mr. Kendall was elected, was, the initial election was November the 2nd, with a runoff on November the 30th. The school board adopted the requirements of this statute on the 27th of September 2011. Those are some just dates that you might need to know that would be helpful. And I don't think anybody disagrees with those dates.
okay, so for purposes of, since Ms. Bryant seems to be somewhat confused about what this letter says, and I'm referring to this Exhibit 1, March 12, 2014 letter from Mr. Allen. And basically, Ms. Bryant, what it says, if you read the last paragraph down at the bottom, it says, thus, if this affidavit requirement applied at the time of qualifying for election and under a state board timeline for local board governance based issued December 10, 2010. This means qualifying on or after July 1st, 2011. The member was required to swear that he or she had agreed to annually disclose compliance with the state training policies. In other words, when I qualified, the law wasn't in effect, okay? The elections that the law applied to were elections that happened after January 1st, 2011. I got elected in 2010. The affidavit requirement did not actually start applying to anybody to have to sign this affidavit until 2012. So, in other words, this whole training regimen and this affidavit requirement that they are talking about didn't apply to me because I qualified in June of 2010, before the law ever came into effect. The second letter from the Deputy Counsel, Mr. Lanier, is confirming that he is in agreement with the letter from Mr. Allen, which in essence says that none of this whole matter applies to me, in complete contradiction to Mr. Shepherd's interpretation of the statute. So you have a choice. You can take Mr. Shepherd's personal political analysis, result-oriented analysis to try to get a result so he can say that I can't qualify, or you can take the Legislative Council's opinion of this matter. You can either read the statute and read what it says for yourself and use common understanding of the English language, or you can take Mr. Shepherd's convoluted approach where you have to read into all this stuff, try to divine the legislative intent, try to go find the legislative minutes, and then he comes up with what he thinks is the intention of the legislature based on all these facts about what happened in Clayton County. So that's what you got here. So you can take these folks' opinion as to whether or not this applies, or you can take his opinion whether or not it applies. And if you take his opinion that it applies and I don't qualify to run for re-election, you got to read all of this stuff in it, and then we're just going to spend some more money going to court, being a test case, because as they just said, there are no cases interpreting this very poorly written statute. So if good people in Spalding County want to spend Spalding County taxpayers' money trying to pursue an interpretation of this poorly regarded, poorly written statute, then you can vote and take his opinion. I would remind you, however, I think one other thing you need to take into consideration. This board needs to take into consideration. Nobody signed up to run against me. Okay? So you have to walk this through.
Hank, just a second.
Can I make my statement though, Mr. Taylor? He had an opportunity to explain all this background.
Wait a minute, let me just say what I'm going to say, okay? That's really not an issue before this board today.
Well, neither was all this stuff that happened in Clayton County.
Well, that's fine, but I really would prefer that you not go into that because I don't think it's got a thing to do with their ultimate decision today.
Well, Mr. Ford, I would respectfully disagree, but however, I respect your ruling in the matter. But my point is this, Ms. Grace and members of the board, this is politics, okay? All of you appointed because of your political affiliations in various parties. This, what we are going through, is politics, okay? And don't get it confused with what Mr. Shepherd is talking about this legal interpretation and how to interpret a statute. This is pure hardball politics, okay? And that's all we got going on here. These guys want to come up with some interpretation. They want to read the statute so that they think, or read it in such a manner that they think I can't qualify to run for re-election. The statute doesn't say anything about any of that. You have to read all of this stuff in there. All right? So, if we are going any further, because I object to any contention that Curtis Jones's records are complete, okay? Because I have called up there to the School Board Association, and according to their records, the lady sent me an email, which I forgot to bring this morning.
We need that.
Claiming that they had no record of me having any training in 2011, 2012, or 2013, when they all know that I was up there this past December with them. We were all sitting there together. Tim and Mr. Westbury and I sat in the training session for lawyers so you could get some continuing legal education training. We all were there. They know I was there. But yet the School Board Association said they have no record of me doing any training. The lady, Ms. White, she sent me an email on yesterday. She was out on Friday. She said, I got to go back and try to find these records, and we'll see what happened to it. I have documentation where the Bar Association got my credit for training, but somehow the School Board Association didn't get it. They don't have it. So that's why I am asking for this continuance so I can go track down these records, because whatever he's saying, I'm not agreeing to it. And it's not factual. And irrespective of how many times Tim Shepard sits here and says there's no dispute about whether or not I got this training, there is definitely a dispute about it. I just haven't had time to go track it down because, as I said in that letter yesterday, I wasn't sure which year they were talking about. Because the very first time Curtis Jones called me and mentioned this to me in November, he told me that I didn't get the training in the first year I was on the board. When I called up there and verified from the people at the GSBA, the School Board Association, they told me I had 18 hours. I only needed 15 hours, but they got a record of me having 18 hours the first year. I reported that back to them. They never said anything else to me about FY 2012. Only thing Curtis Jones told me was the first year you were on the board, which would have been fiscal year 2011. So that's all I checked on. I only found out about this so-called challenge on that Thursday before the qualifying was over, because Reverend Zach Holmes came down here to qualify, and Ms. Collins told him that the superintendent had sent a letter down here questioning my ability to qualify. The superintendent then sent me a copy of the letter. I didn't know anything about. He had sent the letter down here to Ms. Collins, and the first I heard of it was that Thursday when I came down here to qualify. That's the first I knew about this letter that he had sent, because there had never been any discussion about this at the school board. Second of all, Mr. Curtis Jones, he failed to show you that part of that presentation he made yesterday, where it says that the proper protocol for these type of issues is for, you were there, Ms. Grayson, you saw the presentation yesterday. The presentation said, if there is an issue about whether or not this training requirement has been met, the first thing that's supposed to happen is the school board is supposed to discuss it. You saw it. Now, he conveniently forgot to bring that presentation down here to you this morning, ladies and gentlemen, so I have to tell you about it, because he is selectively, as is always, selectively trying to come up with whatever fits his purposes best. But that's the first thing that should have happened. When he says he was being responsible by coming down here bringing this letter to Ms. Collins, I'll remind you, 2 years ago, he didn't bring any letters down here to Ms. Collins to tell Ms. Collins whether or not Mr. Westbury and Ms. Cook, when they had to run in 2012, when this affidavit requirement was actually on the books, he didn't bother about sending a letter down here to inform Ms. Collins whether or not they had completed their training. He only wanted to send this letter down here because he thinks that he's got me, because I didn't do the training. So you need to ask him, what is that video that he showed yesterday that said the proper protocol is for the school board to decide all of this, and if the school board cannot remedy the problem, the next step is to bring the issue to Ms. Collins. He conveniently left that out for you. That's why I'm telling you, this is nothing but personal politics. So, if you go beyond the Legislative Council's opinion, and you determine that Tim Shepard's opinion of the law is the better interpretation of the law, then I want a continuance or a recess. It would be a proper term. A recess to go ascertain and collect all of these records that it's obvious that they have been collecting for some time. But I think it's mighty strange that I've seen Curtis Jones. We had a school board meeting since he sent this letter down here. He's got an email, I got an email. United States Mail Service is still operating. But I never saw that letter he sent to Ms. Collins until Zach Holmes called me and I came down here and picked up a copy. So if they were so concerned and they were trying to be so ethical and they were so much following all the rules, why did they fail to even send me a copy of this challenge to put me on notice so that I could come down here and bring whatever evidence I had? Now, he's claiming that his documentation is the definitive be-all, end-all of all of this, and I'll submit to you, ladies and gentlemen, that it is not. This is just his record. So that's my case here this morning, and if you want to go past the Legislative Council, you need to just give me some time to document all this stuff, and I'll be more than happy to go up there to Atlanta and find all of these documents, because I don't trust a thing that he says, and I don't trust any records that he has about my training.
Well, let me make a suggestion. I didn't cut you off.
No, sir.
Okay. Let me make a suggestion. We'll bifurcate this to this extent. First issue to the board will be whether or not they believe that Mr. Kendall either he is or he is not subject to this ordinance. In other words, does this apply to him or not, in plain English? Okay? If the answer to that is no, then that would be the end of your deliberation, because there would not be, the educational requirements would be moved, wouldn't make any difference. If you decide that these requirements do apply to Mr. Kendall, then at that point you could consider giving Mr. Kendall the recess he's requesting to go get the documents from the state to rebut the evidence presented by the school board that he did not satisfy the educational requirements. Now, is that satisfactory?
My question is, I'm still not sure. If the school board is mandated to do the training, and the school board members are mandated to take that training, does that not supersede this? That's where I am confused.
Supersede what?
Let's let the attorneys respond to that.
Let me respond.
Well, hang on. Do you want to respond to that? Okay, Mr. Kendall, I'll let you respond to it, and then if you want to rebut, fine. Go ahead, Mr.
Well,
Kendall.
see, Ms. Grayson, you have to, first of all, in my opinion, if you think that it applies, okay, let's assume that it does apply, which I'm not conceding. The training that you're saying, that the school board members had to get this training. What does the statute say is the penalty for not training? Okay? Mr. Shepard's interpretation is that if an individual doesn't train, then if you are an elected board member, then the next time you go to qualify, you are ineligible to qualify. That's his interpretation. Now, the Legislative Council's interpretation, if you read this letter, the last sentence in here, in the last paragraph, it says, under the State Board of Education, Local Board of Education Model Code of Ethics adopted by a local board pursuant to Code Section 2272, local board members must participate in required training. Possible violations of the Code of Ethics by a board member are subject to investigation by the local board and may result in sanctions by the local board after a hearing in the matter as provided by the model code. This is in response to Mr. Johnson's question. The sanction for not training is not that you can't qualify to run, it's that you violated the Code of Ethics. And if somebody, Mr. Johnson, who didn't train, the board could take sanctions by having a ethics violation. Now, he's trying to read into this statute. You got to go to a long stretch to read into this statute that the sanction of the penalty for not training is you don't get to run for re-election.
But that is part of the State Bill 85, right?
If you show it to me.
That you signed for next year.
That I signed for the next time.
Right.
I didn't sign for it in 2010.
I know that.
Okay.
I understand.
I signed for it in 2014.
Right.
I signed the agreement. I signed the affidavit because now it is a requirement. When I ran in 2010, it was not a requirement.
I understand that.
So you have to.
When the board adopted that mandate, that's where my confusion is. When the board adopted that
In 2011.
2011, did that not mean this?
Let me read this sentence again for you.
I understand what you're saying.
The language to annual disclose is prospective. If you read the Legislative Council's letter, it says plainly, I mean, I can't really, I don't know what else I can say. The language to annually disclose is prospective. And if you know what that means, it's going forward. It's not going backwards. Okay?
I understand that.
So
I'm fine with that. What I'm concerned about is the mandate that was put on the local school board for training for their members. Where does that come into effect here?
When did it come into effect?
Do they have no recourse if you don't?
Yes, it says right here. The recourse is
Sanctions.
somebody can file an ethics violation against the member. The sanction and the penalty is not that you cannot run for office. That's what they are trying to read into the statute, that the sanction is you cannot run for election. Let me just proffer this question for you. What is a person who has never been on the board, never been a school board member?
We've been all through that. We're not going there.
So,
I understand.
but let me just say this.
I've got it now.
But no, let me just make this point. Let me make this point, Ms. Grayson.
Okay.
Mr. Shepherd is trying to say, we need to try to make sense of the statute. And that's the quote-unquote proper way to analyze and interpret statutes, is to try to make some sense of it. Now, just think about this for a second. Do you actually think that the legislature was trying to make a statement that a person like myself, who has been in office for 3 going on 4 years, and been to all of this training except for maybe 6 hours, is less qualified to be on the board than a person that has 0 hours training? Now, would that make any interpretive sense in any rational person's mind that the legislature was trying to create a regime whereby people with no training are more qualified being on the school board than a person with 3 years experience and all of these hours of training? Now, that to me is what doesn't make sense. Okay?
That's all right.
But in my opinion, and this is my opinion, everybody's got one, Ron, we need for you to prove to us that you do have those hours. That's the only thing.
Okay, well I'm saying this, Brian, everybody, you got to make this threshold question, analysis. Does the statute apply to me, and did I have to train? And if you come to the conclusion that it does apply to me and I had to train, then you go to that step.
Can I respond to Ms. Grayson's question? And this, I promise I'm going to be short. When we're looking at dates, effective dates of the statute, Mr. Kendall is ignoring the last sentence of the statute, which says, this subsection shall apply only to local Board of Education members elected or appointed on or after July 1st of 10. Based on that, if Mr. Kendall was elected in November of 10, the requirements of this statute apply to him. Now, why I disagree with the opinion of Legislative Counsel is Legislative Counsel focuses on the requirement of the unnumbered paragraph to disclose, as opposed to the requirement of E2, which means they have to comply.
Amen.
And if you take Mr. Kendall's interpretation of the statute, it renders subsection E2 meaningless. That's where I'm coming.
I'm sorry, but I do have these 2 words down here: disclose with the star by it and comply with the star by it. Both of those 2 words I want understood.
Well, in my opinion, Ms. Bryant, in order to render Mr. Shepherd's interpretation, you have to insert a word between disclose and compliance, okay, to make it make sense, to come to the result. You have to insert some word in there between them, okay? Now he wants to insert the word does or did comply, okay? That's his interpretation. And that's the way he wants to interpret it because, in my opinion, that fits what he needs. No, or you can read the statute as it is and not try to insert words in there to come up with some meaning. And if the Legislative Counsel, the actual affidavit that you have to sign, if you just read it, if you just read the affidavit, all it says is that you agree to disclose compliance. Now, if you want to insert the word actual compliance in there, like he wants to do, you know, you can do that because we're going to probably end up down at the courthouse and let some judge somewhere tell us, do you insert that word actual in there? Because that's what he has to do to make his theory work. I'm not inserting any words. The Legislative Council hasn't inserted any words. They read the statute as it is. And I'm not ignoring that part that he said. Because if you read the Legislative Council's letter, it says, thus, if this affidavit requirement applied at the time of qualifying, that is the applicable language. Because nobody that ran and got elected in November 2010 qualified after July 1st. All the qualifying took place before July 1st. So what he's saying in this letter is, all of those people like myself who got elected in December, November 2010, this requirement didn't apply to us. They're talking about anybody that qualified after July 1st, 2010. I mean, it says it right here in the letter. That's his interpretation. That's the deputy council's interpretation. So, as I said, you either take Tim Shepard's interpretation or you take the legislative council and the deputy council's, because they are two different, completely different analyses of what they want or what the statute says. As Mr. Fortune said, neither one of them is definitive and determinative. And if we want to get the Supreme Court, because that's where it's going to ultimately end up at, if you decide against me. Now, they can't appeal nothing if you decide for me. I don't think anybody else, it's too late to file anybody else to file a challenge. Am I right, Ms. Collins?
Friday would be the deadline.
Friday would be the deadline for somebody else to file a challenge. So if somebody with actual standing wants to come down here and file a challenge, they're welcome to do it. But these guys can't file a challenge.
Can I say one thing in response to what Brian asked?
Okay, one sec, because what I'm going to basically say is I think we kind of had closing argument here. I mean, anybody, why don't you go ahead and say what you want to say, and then if y'all want to hear some more argument, we can have that, or if you're ready to, I do agree that the threshold question is whether or not this law applies to Mr. Kendall in this situation. If the answer is no, that's the end of this hearing. If you say yes, it does apply, then he has requested a continuance to allow him to get the necessary documents to rebut their contention that he did not get the required education. So, without prolonging it much further, yes, go ahead.
Ms. Bryant, you mentioned the factual issue as to whether or not he got the requirement. You've got, and Mr. Kendall had indicated that the records were incomplete. If you look at the letter that Colonel Jones sent to Ms. Collins, you've got the fiscal year 12 report, which shows the deficit of 6 hours. You also have the fiscal year 13 report, which shows that all the board members got their 9 hours. Those are the complete reports because fiscal year 14 is not due yet. Okay. Second, to get to the heart of the factual issue, I don't have the ability to ask Mr. Kendall anything, but he is under oath. And somebody on the board is invited to ask Mr. Kendall, did he actually attend the training from December of 11? And if he didn't, did he ever make it up between then and June 30th? That's a threshold factual issue. He's under oath. Somebody should ask him that.
Well, that's not a threshold factual issue until you determine that this training is required.
I mean, does anybody, without ruling for one side or the other, that is not going to become material until the board decides that the statute applies to Mr. Kendall. Until that issue, until we cross that bridge, it doesn't make any difference whether he went or did not go to the educational, meet the educational requirements. Because if it doesn't apply to him, it doesn't make any difference. If it does apply to him, then that becomes certainly material, but we're not there yet. And I think that would just, depending upon what this board does, that would just be more surplusage, just additional argument on the same issue. I think they covered it very well about their two relative opinions concerning whether or not the statute applies. Now, I don't want to cut off board members. If they need to hear something more than they've heard so far, then, please let us know. If you are ready to consider the threshold question of does it apply or not, somebody let me know. Yes.
Yeah, I mean, I find the opinion of Wayne Allen about as clear as the code that we're having to make a decision off of. I understand Mr. Kendall's objections or arguments in reference to the days, but in just reading the code, which we're here to make a judgment based off of our interpretation of what we got right here in front of us. My question would be, if there's material evidence that the person, you know, running for this position has not complied, or let's just throw out an example of, and I'm just trying to interpret this because it is unclear. You know, if there was an ethics violation or if there was a conflict of interest, you know, that we were advised about, and that was like a material, you know, breach or whatever, you know, that would that be reason to disqualify? And I'm not sure who to address that question.
What my understanding is, and if either of these gentlemen disagree, then they can say so. I think that if you're talking about an ethics or a conflict of interest violation, you're talking about a hearing before the school board on that issue, and if they determine that an ethics violation has occurred or that there is a conflict of interest, then their remedies, as Mr. Shepherd has pointed out, are quite limited to, quote, sanctions, which would be a public reprimand, a nasty letter in your file saying you shouldn't have done that. That, my understanding, would be the remedies. Anybody disagree with that?
Well, yeah, and actually there was an issue that arose yesterday with regard to Mr. Kendall's violation of the code of ethics that was pointed out by Mr. Westbury during the board meeting. The code of ethics says board members shall not vote on a matter that directly affects them. And Mr. Westbury pointed that out to Mr. Kendall before the vote was taken. Mr. Kendall ignored that and voted on it anyway, and it's Mr. Westbury's interpretation. And I agree with him that that was an ethical violation, but it occurred during his term. He's serving now, and I don't know which way the board, because the local school board has not addressed that yet. I don't know where the board's going to go on it, but I'm just telling that is an issue that came up yesterday.
In responding to Ben's question, the question is that you be limited to some form of sanction, correct? You agree with that? Okay.
But the code here says that, I mean, this is just so unclear, and I'm afraid that you know, some higher court will have to make a ruling on it, because I'm reading it as, you know, subsection E 1 and 2 all together, and you know, I mean, it's all to do with, you know, that you read, you understand, and that you agree to comply with, you know, the rules of the playing field, and that's the way I'm reading it.
Well, but Mr. Johnson, can I respond?
Just 1 second.
Okay.
Are we kind of deliberating now? Or are you asking them questions or what? Because, I mean, if y'all are going to express your opinion, that's all fine and dandy, but that's part of the deliberations. If you've got questions you want to address to them that you're not certain what their positions are,
sure,
then this would be a great time to do that. That you can discuss amongst yourselves, and it will be deliberation will be in the open.
So I guess my question would be in regards to me having this understanding of it. Have you complied with the training requirements as outlined in this case?
The training requirements did not apply to me because when I qualified for this term, there was no requirement to sign that affidavit. There was no training requirement, okay? So it doesn't apply to me. When I qualified the other day, 2 weeks ago, whatever day it was, these training requirements apply. I had to sign an affidavit saying that I agree to annually disclose compliance. I signed the affidavit. That is the only qualification that you have to do to qualify, because that's all we're talking about. We're not talking about what I did in 2010, 2011, 2012, 2013. We're talking about, can I qualify to run for the seat in the office that begins on January 1, 2015? What are the requirements to qualify to run for that term? The requirement is that you sign an affidavit saying that you annually agree to disclose compliance. The qualification requirement, the agreement, is prospective. It's not what I did in 2011, 2010, 2013. It's what am I going to do in 2015, 16, 17, 18. So whether I did all that stuff in 10, 11, 12, and 13, 14 is irrelevant. That's my position on it.
Okay.
And I agree with the Legislative Council. It's prospective, not retrospective.
I think I actually asked a direct question as far as, do you think you fulfilled the training requirement?
I just said, I don't have all the records. I need some time to go ascertain all the records. See, if I had all the records, I would have brought them in here. Had I been put on notice of which year they were talking about, because if you read the letter that he sent to Ms. Collins, it doesn't say which year we are talking about. It doesn't specify which fiscal year they are referring to. When I asked, I sent an email to Mr. Fortune last week, and I sent that letter down here yesterday. Can somebody just please tell me which fiscal year are we referring to, and how many hours are they saying that I am in deficit? Nobody has given that to me. Mr. Shepard is trying to say, oh, all you got to do is look at the records. It's not for me to divine. These guys are making an allegation. The Board of Election is making the challenge. It's not for me to go and try to figure out what the challenge is. The person who makes the challenge has to specify what the challenge is.
Well, I think we all understand.
Okay, all right.
Michael, excuse me just a second. You said that it did not apply to you, that there's none of this stuff applies to you. But then you go back and say that you did get some training. So, is that you, I just need to know which of those is the truth.
What you mean, which is the truth?
That it didn't apply to you or that you had the training.
They both could be true.
Well,
I could have the training and it still doesn't apply. What you mean, which is the truth? They're not mutually exclusive proposition, Ms. Bryant.
Well, they would be to me.
No, they wouldn't be. I had 18 hours training in 2011. I only had to have 15. Okay? Even if it didn't apply.
Excuse me. Well, sorry, but this is going to get nowhere. Because the records that Mr. Kendall would need to support his position are not here, and he has requested a continuance. My recommendation is, unless you've got some specific questions that are zeroed in on the issue of whether or not this statute applies to him, or whether he was subject to those requirements. If you don't have any more questions on that, then I would suggest that you approach and make a decision on the issue of, does this statute apply to Mr. Kendall in these circumstances? If the answer to that is no, that's the end of it. If your answer is yes, then you need to consider his request for a continuance or recess to allow him sufficient time to get the records from the state on the issue of what education did he get, was it sufficient, yes, no, whatever. Now that's my recommendation. Is that all right with the board, or is somebody going to say, I don't like that idea?
I do.
Billy, do you have a question?
I think that's the only options that we have. You know, I mean, we can vote on whether the president, whether he is qualified or not qualified. You know, without whether that old statute or the statute applied to him or not is immaterial to me. I mean, what difference does it make? You know, if he's complied with the eligibility requirements, okay, sign the affidavit, I mean, that's all we got to consider.
But that's for the next term.
That's
But
for the
that's
next.
all.
He didn't sign.
We haven't got anything to do with the prior term, have we?
That's what
But
we're,
that
that's
is
where
the
our
issue
That is the issue.
that I continue.
The issue is whether he is eligible for election now, based on past experience. He never signed the oath because there was not an oath then for him to sign. So his contention is, since he didn't sign the oath, we cannot hold him to an oath. That's basically.
That's not just my contention, Ms. Grace. That's just
No,
simply what it says.
that's your side.
Yeah, right.
Goes to this.
I'm not sure. Again, can you hear me okay? Yeah. That's what I'm.
Oh,
Hang on. What I'm suggesting that the board do is that the threshold question before they need to go any further is to determine, in your opinion, whether or not this statute applies to Mr. Kendall because he qualified before the effective date of the statute. There was no affidavit in existence at the time. So does the statute even apply to him? And if you conclude that it does not apply to him, then that is the opinion of legislative council, nothing but an opinion, then his educational requirements are moot. Doesn't make any difference whether you met him or not, because the law didn't require him to. If you determine that he is subject to this law, that it does apply to him in the situation before you today, then the issue of whether or not he has met the educational requirements becomes a very material issue. If you get that far, and Mr. Kendall has requested a recess in that event to allow him time to get the records from the state board. Now, I realize you have a difficult time hearing, so if there's something that you're not sure on, ask me, okay? Or you?
okay.
You
I understand what you're saying, yeah.
Okay, all right.
That doesn't mean I agree with it, I mean,
Okay, no, you don't have to agree with me, I'm not important.
Okay.
I just want to make sure you heard me.
Okay.
All right.
RMS, have you any questions?
No. But before we vote, I would like to make a statement.
All right,
Yeah.
go ahead.
Mr. Fortune, you serve as counsel for Spalding County.
Yes,
And when there's a situation that comes up, they confer with you.
sometimes.
Mr. Shepherd, you counsel for the school system. Yes. When a situation comes up, they confer with you.
I'm kind of like Mr. Fortune, hopefully.
I understand. My point is, with this piece of legislation, we have to rely on the opinion of the council for the legislation, because they were involved in those proceedings. I think they have a better idea of the intent of which the law was supposed to do. And based upon that, I would have to rely on their opinion that this does not apply to Mr. Kendall in this particular situation. I would also like to thank Dr. Jones for bringing this to our attention so that we would be better prepared in the future when a board member seeks re-election. But in my opinion, this is a moot point. It does not apply to this situation, and I'm ready to vote, Madam Chairman.
All right, anyone else have any discussion? All right, then the question is, does this statute apply to Mr. Kendall to keep him from qualifying?
Well, let's restate that.
All right.
The first question is whether or not Mr. Kendall whether or not he is subject to the requirements of the statute.
Okay.
Either yes or no. If the answer is no, then that's the end of your deliberations. If your answer is yes, then the question of whether or not he met the educational requirements would come into play. So the first issue, or the first factual determination you need to make is whether or not this statute applies to Mr. Kendall in the present setting before you today. That's the issue.
Well, Mr. Porter, can I just, for the purpose of the record,
Please.
for the purpose of this record, I think this question needs to be crystal clear for the purpose of this record. As Mr. McDaniel was saying, the issue before this board, and now I just want to kind of restate what you said. The issue that you have to determine, in my opinion, is, am I able to qualify to run for the school board seat in 2014? Yes or no, based upon whether or not I took these training classes in 2010, 2011, 2012, 2013. That's really the issue, as Mr. McDaniel said. You have to determine, am I a qualified individual to seek this office right now in 2014 based upon what I did or did not do in terms of taking some training in these previous years? That, for me, is the issue.
Well, that may be, but whether or not you have met the educational requirements, which seems to be an issue here, would be totally moot if the board were to determine, as I previously stated, that the statute doesn't even apply to you.
Yes,
we don't need to worry about the rest of it.
Yes, that's what I'm saying.
Well,
We're on the same page,
Okay.
I think.
Does everybody understand what the question before the board is? Whether or not the statute applies to Mr. Kendall is the issue to be first determined. Depending upon your determination, we may or may not have to go further than that. Okay? Is there any uncertainty as to what the issue is? Okay. The question is, if you believe that the statute does apply to Mr. Kendall, then would you please raise your hand? Okay, got one vote. Do you believe that the statute does not apply to Mr. Kendall in the present setting? Would you please raise your hand? 4. Madam Chairman, I think that pretty much ends your deliberations.